Assalamualaikum and hi to everyone. Today our group would like to present about securities offences. There are two methods of regulating the securities industry, which is licensing certain persons before they undertake operation within the securities industry and disclosure of information about certain persons' securities activities. The offences relate to both physical acts and the passing of information, false or misleading statements. The relevant laws are CMSA Securities Commission Act, Securities Industry and Companies Act. We examine each of the following areas which are regulated: short selling, false trading and market rigging transactions, stock market manipulation, false or misleading statement, fraudulently inducing person to deal in securities, use of manipulative and deceptive device, dissemination of information about illegal trading, and others. First, trading in securities prohibited conduct under the CMSA. Short selling. Short selling is the practice whereby the seller sells securities which at the date of the agreement for sale it does not own, but it tends to acquire before the delivery date. The seller that engaged in short selling is relying on the market price of securities dropping between the date. Naturally, short selling is more prevalent in bear market where the odds of such a decline in price are considerably better than in a bull market. The danger of short selling from securities market is that seller may be able to purchase the securities in time for delivery and will therefore default on the contract. In Section 98 of CMSA prohibits a person from selling securities to a purchaser unless at the time of sale the person or their agent has presently exercisable and unconditional right to vest the securities in the purchaser. However, CMSA also set out a limited number of circumstances in which short selling is permitted. Read section, which particularly in relation to outlawed pre-existing contract, a sale of securities permit by bank negara to be transacted, and securities as prescribed by the minister. The last item is the major exception to the rule against short selling. A regulated short sale must be stipulated in the contract note, only executed by a participating organization, only executed through ATS and others. The penalty of short selling is a fine of up 5 million or imprisonment for up to 10 years or both. The example case of short selling is PPV Fang Aheng and PPV Mohamad DRAHMAN. Section 175 False Trading and Market Rigging Transactions. Section 175(1) of CMSA prohibit a person for creating, causing to be created, or doing anything that is calculated to create a false or misleading appearance of active trading of, or a false or misleading appearance with respect to the market, and a false or misleading appearance of the price any securities on market in Malaysia. Section 175(3) provide that a person shall be deemed to have create a false or misleading appearance of active trading if such person has entered into a transaction. Section 175(2) of CMSA prohibits a person by means of purchase or sale of securities that do not involve a chain of ownership or fictitious transaction or device. Section 176 Stock Market Manipulation. Section 176(1) of the CMSA prohibits a person from entering into transactions that have likely to have the effect of raising, lowering, or pegging, fixing, maintaining, or stabilizing the price of securities for the purpose which may include inducing others to acquire or dispose of the securities of the corporation or related corporation. A transaction includes unexecuted bids and offers. This is irrespective of whether another person is induced. Section 177, false or misleading statement in relationship to securities. A person must not make a statement or disseminate information that is false or misleading in the material particular and is likely to induce the sale or purchase of securities by other person, and is likely to have the effect of the raising or lowering, maintaining or stabilizing the market price of the securities. When he or she make or disseminate it, the person does not care whether the statement or information is true or false, or knows or ought to reasonable know that it's false or misleading. Section 178, fraudulently inducing person to deal in securities. It is an offence to induce or attempt to induce another person to deal in securities by making or publishing any statement, promise or forecast that the maker knows to be misleading, false or deception. Dishonestly concealing material facts, reckless making or publishing dishonestly or otherwise any statement or promise or forecast that is misleading, false or deceptive. Persons subjected to this prohibition include officer of a company in relation to a company prospectus, or to be stockbroking company advising client or about an issue of sale of securities. Finally, this section extends liability to a situation where a person is not necessarily acting dishonestly. The requirement that the statement be reckless is not met by mere negligence, being the failure to take reasonable care. The effect of Section 178 of the CMA is, among others, to impose on directors and other person making statement by way of inducement a duty to inquire whether the information they have been given is correct and reliable.
1.6 Section 179, use of manipulative and deceptive device. It is an offence if, in connection with a sale or purchase of security, a person directly or indirectly uses any device, scheme or artifice to defraud, engage in any act, practice or course of business which operate and will operate as a fraud or disease, make any statement which is untrue of a material fact, or omits to state a material fact necessary to make a statement, not misleading on the content in which it was made. This section instead the circumstances in which the Act applies in the respect of materially untrue statement and omission, and incorporate the common law action of fraud and disease. 1.7 Section 181, dissemination of information about illegal transaction. If a transaction is entered into the conservation, it is an offence for a person to circulate or disseminate a statement or information that indicates that the transaction will affect the price of the security if the person has entered into the transaction. 1.8 Insider trading. The first one is rationale. The rationale for prohibiting insider trading includes the following: fairness and transparency in the marketplace, equal access to information for all market participants, market integrity, corporate disclosure and good corporate governance, provision of injury to the company, its shareholders and investors. CMSS provision. There are now two limbs to the prohibition in insider trading. Firstly, any person who possesses inside information is prohibited from trading in the relevant securities. Secondly, a person who possesses inside information is also prohibited from communicating that information if the insider knows or ought to reasonably know that the other person will tend to trade in the relevant security or procure a third party to trade in the relevant security. Insiders include all persons who have in their possession information which is not generally available, which, on becoming generally available, A reasonable person will expect it to have material effect on the price or value of securities and knows or ought to reasonably know that information is not generally available inside information. Such person may include a member of a director family, a body corporate which is associated with the director or subsistence shareholder. Number 4 is information. Information includes matter of supposition and other matters that are sufficiently defined to warrant being made known to the public. Matters relating to the intention or likely intentions of a person. Matters relating to negotiation of proposal with to respect commercial dealings or dealings in securities. Information relating to the financial performance of corporation. Information that a person proposed to enter into has a previously entered into one or more transactions or agreements in relation to securities or has prepared or proposed to issue a statement relating to such security. Matters relating to the future. Number 5 is information generally available. It provides the information is generally available if the information has been made known in the manners that will or will tend to bring it to the intention of reasonable person who invest in security of a kind whose price or value might be affected by the information. And since it was so made known a reasonable period for it to be disseminated among and assimilated by such person have elapsed. This includes information that consists to deduction or conclusion made or drawn from such information. Number 6. Material effect on price or value of securities. Information that, on becoming generally available, will or will tend to have a material effect on the price or value of securities refers to such information which will or will tend to, or becoming generally available, influence reasonable person who invest in security in deciding whether or not to acquire or dispose of such securities or enter into an agreement with a view to acquire or dispose such securities. Referring to procure, the meaning of the term procure as provided in this section, if a person incites, induces, encourages, or directs an act or omission by another person, the first mentioned person is taken to procure the act or omission by the other person. Exception to liability for insider trading are contained in relation to underwriting and sub-underwriting transaction carried out under scheme of arrangement under any right to law, corporation with knowledge of its intention, knowledge of an individual's own intention or activities, unsolicited transaction by a broker and redemption of units of a unit trust scheme under by the bank covenant. Defense. It provides several such as the security that are the subject of the transaction or agreement or the action of procuring a transaction or an agreement are not securities which are permitted on the stock market of the stock exchange. The court is certified that the other party to the transaction or agreement know or ought reasonably to have known all the information before entering into the transaction or agreement. A person acquires or disposes of such security on the term and in such circumstances that the first is he does not obtain any gain or avoid any loss, including unrealized gain or unrealized avoidance of loss in price or value of the security as the case may be for himself or any other person by reason of the effect that the information is likely to have when it becomes generally available. The secondly is the purpose of the acquisition or disposal of the security does not include any purpose of securing a gain or avoiding of loss, as the case may be for himself or any other person by reason of the effect that the information is likely to have when it becomes generally available. When the person communicated information or caused information to be communicated to other person, it should be a defense. If the court is certified that the information come into possession of the person so communicating the information slowly as the result of it being known in the manner likely to make it generally available, or if the court is certified that the other party know of or ought to reasonably to know the information before the information was communicated. 1.9 Penalty for contravention. Criminal sanction. The penalty for a contravention of the section discussed earlier is a fine of at least Rm 1 million and an imprisonment for up to 10 years. In addition, it provides that a person convicted of the offence discussed above is liable to pay such compensation as may be determined by the court. Civil proceedings. It provides that a person who suffers loss or damage by reason of or by relying on the conduct of another person who has contravened by recover the amount of loss or damage by instituting civil proceedings against the other person. An aggrieved person may, by civil action, recover the difference between the price at which the security were required or deposits or agreed to be acquired or deposits by the insider or the other person from the seller or purchasers, and the price at which the security will have been likely to have been acquired or deposited at the time of acquisition or deposit or agreement, as the case may be if the information had been generally available. The SC the power to initiate civil action against the insider or any other person involved in the contravention to recover the amount equal to the 3 times the amount being the difference between the price at which the security were acquired or agreed to be acquired or deposited by the insider or other person, and the price at which they will be likely to have been acquired or deposited at the time of the acquisition or deposit or agreement, as the case may be if the information have been generally available. The lastly is claim civil penalty up to the sum of Rm 1 million.
Next is others offences relating to dealing. Apart from offences discussed above, there are several offences which relate to dealing in securities. They have been discussed in previous topics and are briefly as follows. Firstly, dealing in securities without a license. Section 58(1) of the Capital Market and Services Act 2007, which is requirement for capital market services license. For Section 58(1), no person shall, whether as a principal or agent, carry on a business in any regulated activity or hold himself out as carrying on such business unless he is the holder of the capital market services license or a registered person. Secondly, dealing as principal without so informing client. Section 97 of the Capital Market and Services Act 2007, which is dealing as principal. Section 97 as stated on your video. Next is failing to give priority to client order. Section 93 of the Capital Market and Services Act 2007, which priority given to client order. Section 93 as stated on your video. Next is duty to maintain secrecy of information relating to depositor account in the Central Depository System (CDS). Section 43 of the Securities Industry Central Depository Act 1991 that state duty to maintain secrecy. Section 43(1) as stated on your video. Lastly, fraudulently inducing person to invest money. Section 366 of the Company Act 1975, revived of 1973. For Section 366, as stated on your video.
Next, I will proceed to other offences part. This part consists three parts, which is destruction of document of falsification of record, failure to cooperate with the Security Commission, and liability of director or employers. For the first part is destruction of document. As we know, the Capital Market and Service Act or CMSA contains a penalty in relation to the falsification of record by any person and also a penalty for destroying, concealing or altering record or sending record of other property out of Malaysia. This act provided under Section 368 and Section 371 in CMSA. Then we proceed to the second part, which is failure to cooperate with the Security Commission or SC. As we can see at the Security Commission Act, SCA have three situations of person who fail to cooperate with the Security Commission in any of instances stated in SCA is guilty of an offence. The first situation is failure to appear before an investigating officer or refusal to answer questions put by an investigating officer. This stated on Section 134(5) of the SCA. The second situation is failure to produce record and request. This stated on Section 128(7)(c) of the SCA. And the last situation is obstruction or hindrance of Security Commission investigating officer in carrying out an investigation. This stated on Section 128(7)(b) of the SCA. Lastly, we go to liability of director or employers. In Section 367 of the Capital Market and Service Act, CMSA, corporation committing an offence will be subject to appropriate action based on this act. The liability extends to director, chief executive officer, and officer or representative. Action will be taken unless he or she proves that the offence was committed without prior consent or connivance. Other than that, action can be taken when he or she exercise all such diligence to prevent the commission of the offence as ought to have been exercised. In addition, a dealer, fund manager, or investment advisor is deemed to be liable for contravention of any of the section by one of its representative as provided for under Section 367(3) on the CMSA. In Section 370 of the CMSA, it is also an offence for person to attempt to commit such offence, abet an offence, or be engaged in a criminal conspiracy to commit any offence. The provision to the CMSA and SCA enhance the enforcement powers of the SC and Bursa Malaysia Security Berhad. The parties required to comply with the relevant rules have been widened to include advisors. Then we go to other enforcement action. In this last part of the topic, We can see, besides instituting criminal and civil proceeding, the Security Commission can also make an application to a court for a range of orders as prescribed under Section 360 of the CMSA, as well as under the inherent power of the court. In addition to the provision of the CMSA discussed here, Bursa Malaysia Security Berhad's corporate disclosure policy on insider trading that the insiders should not trade on the basis of material information which is not known to the investing public. Lastly, the Security Commission has power to compound offences under Part 2, 3, 6, 7, 10 or 12 of the CMSA, namely breaches of licensing provision, record-keeping provision and the account and audit provision.